We're here today on initial permanency hearings in each case. We're conducting this through Zoom. We're live streaming. And Ms. Taylor's making our record. All right, we'll go ahead and take announcements.
Daniel Trout for the Texas Department of Family and Protective Services. Tiffany Brown's my permanency specialist. We are present and ready. Your Honor, is Mr. Hammonds here?
Not seeing Mr. Hammonds, and he is not in the waiting room.
Okay, I didn't get a signature from him, so.
Okay, maybe he'll get logged in here.
Thank you.
Joel Jackson on behalf of the mother, Lakeisha Stotts, present and ready, Your Honor.
Vince Nowak on behalf of Cameron Shelton, who's the father of Indiana. Mr. Shelton and I are both present. We're ready, Judge.
Stacey Zabala on behalf of the kids.
All right, then. What do we have new from St. Francis since our court report was filed?
Since the court report was filed, we did get drug screenings back from both Lakeisha Stotts. She was positive on a UA and on a hair strand for marijuana. And we did get a hair strand result back for Mr. Shelton, and he was also positive for marijuana.
Okay, anything else new?
No, Your Honor.
All right, is Arrow still in the respite home?
All three girls are still in respite homes. There
Okay.
is a disposition staffing for this afternoon at 2:00 p.m. for the investigation.
Okay, all right. Where do we stand as far as completion of services? What do we have left to do?
For Lakeisha, she does have to do another OSAR since she is positive again. I did send a referral in for that 2 weeks ago. I tried to get a hold of Sarah Fuentes that does the OSAR assessments to see if that's been scheduled. I've not been able to successfully speak with Sarah directly. And as far as Mr. Shelton goes, he still has most, if not all, of his services to complete. He's completed his. That is the only certificate that I received from Mr. Shelton since the beginning of the case.
He has, hang on. I heard he has completed and then you cut out.
He's completed his TPC assessment and his psychosocial. And he's completed his OSAR.
Were there recommendations by TPC?
No recommendations from TPC. The recommendations from OSAR is for him to attend the Padre program, which I've confirmed with Antonio Graves that they have received his referral.
Okay, so he also did an OSAR assessment.
Yes, ma'am.
All right, and I think Mr. Hammonds has joined us, so just for the record. Okay, what about Mr. Aguilar? Any progress there?
Mr. Aguilar is still incarcerated. To my knowledge, he took a deal and he'll be incarcerated. He's just waiting to be sent to state jail. I had not been able to see him in the months of January and February due to him being in solitary confinement and on restriction for visitors.
Okay. How are the therapeutic visits going between mom and the oldest child, Indiana?
We did receive a recommendation from the therapist. The therapist for Indiana recommends that mom do more parenting classes and that they continue the therapeutic visits.
All right, have you talked with mom about that?
No, we just recently got that recommendation. We do have to try to find another parenting class that will be more specific to what the therapist for Indiana is requesting. She has already completed parenting through OSAR. She just needs to use a different avenue.
Say that again, Ms. Brown.
She completed parenting through the Padre program, but the parenting that Indiana's therapist is recommending is more age appropriate for Indiana. So we have to find a different avenue for Ms. Stotts to attend a different parenting class.
All right, then. Anything else from St. Francis this morning?
We would like, Your Honor, to decide on whether or not visits will continue since both parents have tested positive.
Both were just for marijuana, correct?
Correct. LaQuisha was positive in October, November, December, negative, and positive in January, negative in February. However, she tested positive in March, and Cameron has been positive throughout the life of the case.
Okay, I'm not going to stop visits because the marijuana use doesn't necessarily present a danger as far as, you know, transmitting that to children. But I say that admonishing parents that you've got to understand that marijuana is still illegal in Texas, so you're still engaging in an illegal activity. And, you know, if I had $1 for every time somebody looked at me and said, "Oh, it's just pot," you know, I could be retired. But, you know, bottom line is, folks, it's still illegal. And, you know, so I'm not going to stop your visits, but I'm just going to admonish you that you're going to have to make some choices. So you can light up and smoke dope, or you can work towards getting your children home. And it's pretty much that simple. Okay, Mr. Jackson.
A few questions for her. Ms. Brown, Lakeisha, you were aware that she was in the Senate program and that she was subsequently dismissed from that program, right?
Yes, sir.
And that was because she had tested positive for marijuana. Is that correct?
It's my understanding from Leanne Moses, who is the instructor at Senate that she tested positive in February. She had actually, and she had just tested her a second time in March when I spoke to her, and she let me know that if she had tested again twice positive, that she would discharge LaQuisha from her program.
Okay. Are you aware that she's been accepted back into the Senate program as of yesterday?
No, sir. I tried talking to Leanne on Friday, left her a message. She has not returned my call.
Okay. If Lakeisha can successfully complete this Senate program, would the department be opposed to her having more access to her kids? In other words, 4-hour visits. I mean, I think she travels to Lubbock to do these visits.
No, we are not opposed to increasing her visit time.
Right? You're just waiting to see her successfully graduate Senate.
We have not staffed increasing visit time. She has not asked to increase her visit time, but we're not opposed to increasing visit time. She is getting a separate visit with Indiana with the therapist when it's scheduled. I believe there's one scheduled for tomorrow. And so we can definitely look at increasing visit time since she's been consistent.
Okay, thank you. I'll pass the witness, Your Honor.
All right, Mr. Nowak.
Thank you, Judge. Just briefly, Tiffany, has Cameron been visiting with the child?
He has been visiting with Indiana, yes, twice a month for 2 hours, the second and fourth Thursday of each month.
And are those visits going well?
Yes, we've had one visit where Indiana was sick last week. The respite provider forgot about the visit, but immediately took her over. There are things on our end that we're trying to iron out for Cameron in visiting his children.
Sure. And to your knowledge, Mr. Shelton has been appropriate during the visitations with his kids, correct?
Yes, sir.
That's all I have, Judge. Thank you.
All right, Mr. Hammonds.
Was it your understanding that Adam Aguilar was waiting to go to a substance abuse facility?
No, I spoke with his father maybe 2 weeks ago, and he said that he was waiting to go to TDCJ, I believe, and they
Okay.
they have not found out when that will be yet.
Okay, Judge, I will call the DA today, and I'll call Mr. Aguilar and find out exactly. Because last time I spoke to Mr. Aguilar, I thought he was taking probation. They were going to send him to Safe Peace, so that was going to be about 9 to 10 months of his future. But if that changed, I mean, I'll find out. So I have a pretty good idea of when he'll be getting out.
And Judge, I may be able to answer some of that. I'm looking at the documents right now. It looks like on February 22nd, there was a plea and a judgment of conviction put in for 3 years institutional division at TDCJ.
Okay.
I don't see anything that says that it was probated on this case.
Yeah.
Um,
And Judge, I can just tell you in all likelihood, from my experience, he may do a serve-all on that, so he may not be able to, have much input here in 6 to 9 months, so. But I'll call him and, I'll have everything explained to him.
Okay.
and
Yeah, easier while he's still here.
and Judge, there was a second case that he got 12 months on. So a 3-year and a 12-month conviction for the last ones I see.
Gotcha.
Everything concurrent.
That's all.
Yes, ma'am, I'm pretty sure it was.
I have nothing else, Judge.
All right, Ms. Zavala.
Ms. Brown, the report details some chaos maybe at visits, but that it looked like it was getting better. Are those visits continuing to get better? The ones with all the kids?
Ones with all the kids, they were a little chaotic in the beginning. They got better in January, according to the notes. February is hit or miss. We are trying to get some interventions set up for the visits, because it is done in a counseling center. Unfortunately, they don't have the time before the visit to meet with LaQuisha to kind of give her some, what they call it, parenting coaching sessions. But they are working on moving the visit to a different day to where they could get that intervention set up so that we have more successful visits.
And how long have the individual sessions with Indiana been going on?
They've been started since the beginning of the year. They've had 2 completed sessions. They have one tomorrow. And then it'll be basically set up by Ms. Stotts based on her schedule when she can go out there and have that one-on-one time with Indiana. Indiana has a lot of behaviors that we're trying to address while in care.
The report talks about an incident at school. Have there been more and more incidents with Indiana?
There have been, and with spring break last week, there have been more incidents at daycare that have not been previously reported, but same behavior, throwing chairs, throwing tantrums.
And is the thought behind the individual time with mom and Indiana, is that may help level Indiana out for both the visit time and school time?
Yes, ma'am.
Okay. I have no further questions, Your Honor.
What is it that during the visits, what specifically is it that's not successful right now? Is it more attributed to Indiana's behaviors, or what are we having struggles with?
Predominantly, it is Indiana's behaviors, but it's just kind of overwhelming. And Ms. Stotts can correct me if I'm wrong, to have all 3 of them together. Indiana sometimes wants all of mom's attention. Egypt does, she does throw tantrums, or she just starts crying and screaming and is inconsolable. And then you have the toddler Errol, which her behavior is not, reported to be adverse, but with all 3, with the 2 older girls having behaviors and wanting mom's attention, she has to learn how to divide it and how to get them all to just be on one calm level. According to the notes, it's often chaotic.
So okay, the girls are all placed together there, correct?
Currently, they're in 2 separate respite homes.
All right, 2 separate homes. Okay. Indiana's by herself.
Indiana and Egypt are together.
Okay.
And so that respite mother has been reporting some behaviors from both of them. She reports that they're not basic level of kids, that they probably need to be leveled up to moderate.
I know they're very young, but is there a possibility of the therapist working with those 2 children together, where those 2 children work on not, competing constantly for attention? And
Indiana's more, she's 6 now, so she would be more successful with therapy. With Egypt being 2, it's kind of hard. I did receive a video from placement last week. It was about 12 o'clock midnight, and Egypt was just laying down watching Coco Melon, and she just randomly starts screaming for no reason, nothing triggering her or anything. We are trying to figure out what the triggers are for that and why that's happening. She did have a psychological done. She was supposed to have a behavior assessment done by ACI, but with her being in the respite home, they have to wait. They're waiting for the kids to be returned to the foster home to assess her behavior. Even though she's 2, it's a little out of hand because she's known to just start screaming out of nowhere.
Is she verbal?
She is receiving speech therapy and occupational therapy. She's a little delayed as far as speech and motor skills.
But is she able to communicate her wants,
She does not speak full
needs, her?
sentences.
Okay, but is she able to communicate to placement, you know, what she wants, what she needs, what she's upset about, even in short, you know, 1 or 2 words, or?
No, but it might just be because it's in the respite home and not the regular foster home. When she's in the regular foster home, that foster home is able to get her behaviors under control. And what's interesting is that both girls, their behaviors are not reported in the home. It's only reported at daycare or at school. They don't do it at the foster home.
Okay.
They have had to end at least 2 visits due to behaviors being out of control.
So is it accurate that some of these behaviors have escalated since being in the respite home? Otherwise, they were not so prevalent in the foster home other than at school or daycare?
Yes, ma'am.
Okay. And if that staffing moves forward and that investigation is closed, will they be moved back to the foster home?
That is our intention, yes.
Okay. All right. Anybody have anything further?
So, real quick, Your Honor, Ms. Brown, I believe you asked earlier, since mom tested positive again, to do another OSAR. Is that correct?
Yes, sir.
Does that change with mom being accepted back into Senate? Do we need that done, or are we going to, let's see if she completes Senate?
Like I testified to earlier, I tried to get a hold of Sarah to see if she needed to, if we could get her reassessed. I don't know how she was able to re-enter the Center Core program without another OSAR.
Okay, thank you.
Mr. Jackson, do you have any additional information about that?
Well, I was going to call my client to testify to that, Judge.
Okay. All right. I'd like to know about that. So if you'll speak up a little bit.
Yes, Your Honor.
Thank you.
May I proceed, Judge?
Yes, you may.
Okay, Lakeisha, during the pendency of this hearing this morning, you've been present here with me, right?
Yes, sir.
And I guess I'll start at the end and work my way forward. There was some discussion about you having to take an OSAR or not. And you had applied for or made application with Senecor recently.
Yes.
Is that right? All right. And so were you accepted into the program?
Yes, sir.
How were you able to do that without taking another OSAR?
I just asked
Yeah, you just asked them.
my instructor
Okay. And so, and their response was?
that I was eligible for reacceptance.
Okay. To your knowledge, are they relying on the first OSAR, or do you know?
I don't know. I believe they're probably relying on my first one.
Okay. And that's 30-day program?
It is a 8-week program.
8-week? Okay. And as far as the kids are concerned, are you asking for these kids to be placed together as soon as possible?
Yes, sir.
Okay. And also there was some testimony here about their behaviors. The behaviors of the kiddos had escalated. Did you observe that?
I believe their behavior has gotten better since being separated, sadly. And I think it's because they have more one-on-one time with their caregiver. Even in our visits, they're a little more behaved And that's why I'm assuming that's why, because my last visit was my first visit where Indiana and Egypt were placed in the same home. And their behavior was a little, it wasn't terrible, but it wasn't what it was the week before, where they were happy to see each other, happy to play together, happy to play with me, rather than fighting for my attention.
Okay.
Indiana and Egypt were bumping heads a little at our last visit.
Okay.
Ms. Taylor, hang on, Ms. Taylor, did you get that last part?
I got it, but it's very soft.
Okay.
I'm sorry, I'm trying.
No, I tell you what, instead of looking at Mr. Jackson, if you'll look towards the camera and microphone, I think that will take care of it.
Okay, yes, Your Honor.
And ma'am, there was some testimony here about Egypt's progress as far as the child's speech is concerned. Is this child able to communicate with you?
Yeah, she communicates with me very well.
How does she communicate with you?
I ask her questions that she is able to answer. Like when she's throwing her fits, I ask her like, "Are you upset?" And then I'll ask her like, "Are you upset because your sister took your cup? Or are you upset because of the crayons? Are you upset because of the music? Like, what's upsetting you?" And she'll say yes or she'll say no, and we'll just progress from there.
Okay. And so you just try to throw out as many questions, yes or no questions for her to try to get the answer, or try to get her to communicate with you.
Yes, sir.
What's going on in her little head.
Yes, sir.
Okay.
And she's pretty good about answering.
Okay. As far as the visitation is concerned, are you requesting more time, more visitation with your kids?
Yes, sir.
And they had talked about trying to get maybe some counseling for you and the kids together. Do you think that would be beneficial?
Yes, sir.
And are you asking for, you're getting 2 hours now, are you asking for 4 hours of visitation?
I would prefer like a Saturday visitation if we could do that.
If that's possible.
If that's possible, because I have a place that I can stay in Lubbock to make it a little easier for me to get up there or to get to them on Saturdays.
All right. And that period of visitation for you and the kids, do you believe that if you were able to have that kind of access to your kids, that it would be in their best interest?
Oh, yes.
Okay.
Especially with Indiana's behavior at daycare and school.
So are you of the mindset that perhaps the more time that you're able to get with these kids, then the quicker that you and them can get leveled out as far as behaviors are concerned?
Yes, sir.
What makes you believe that?
I don't know. Something about a mom's touch is right for kids.
Your Honor, I'll pass the witness.
Okay, let me just, well, does anybody else have any questions they want to ask Ms. Stotts?
Just briefly, Judge, if I may.
Sure.
Ms. Scotts, so Indiana's in respite care, correct?
Yes, sir.
And I heard Ms. Brown testify earlier that the plan is to move her from respite back into foster care when the time is appropriate. You heard that,
Yes.
correct?
Yes, sir.
Based upon your visits with Indiana and your observations, do you have any concerns about Indiana being moved back to that foster care?
I don't have a problem with the foster home itself, but I feel Indiana is looked over in that foster home because of her younger sisters and because of the older child the 6-year-old that is in the home already. So I feel like that's why her behavior has gotten better since being in respite care, is because she's not looked over as much as she was in that foster home.
Would it be fair to say that Indiana is apprehensive or uncomfortable going back to that foster home?
Oh, yes. She's expressed that to me.
Your Honor, that's all I have. Thank you.
Right, anybody else have any questions from Stotts?
No questions.
Not from Ms. Stott, yeah.
Okay, so let's go back to let's pose this question back to Ms. Brown. I know Saturdays sometimes can be worked out. I don't know whether in this situation it can be. Probably Ms. Stotts, that's something that Ms. Brown will have to look into. You know, I can't just necessarily say, yes, that's going to happen, or no, it can't happen today, because, you know, it's an issue of who is available to supervise and where and all that. So Ms. Brown, is that a fair assessment?
Yes, Your Honor.
Okay. I would like for y'all to at least look into that, because if she's got somewhere in Lubbock she can stay where she could spend a little more time, I don't disagree with Ms. Stotts. I think increasing time, is sometimes a really good thing with kids. So, let's take a look and see what we can do.
Okay. There's also the issue of transportation because we've been taking her to the bulk of her visits. We don't have transporters available on Saturdays, so she would have to be responsible if we could find a monitor on Saturdays to get herself to Lubbock and back.
Okay, so Mr. Jackson, that's something you all need to talk about. Is that feasible?
Yes, ma'am. I just asked her the question, but that's something that she could do, and she indicated that she could, as far as her transportation is concerned.
Okay, would that be, Ms. Stotts, is that something or somebody that it's very dependable and that,
Yes, Your Honor.
okay. All right, so I guess Ms. Brown, let's look into it and see what we can come up with.
Yes, ma'am.
Judge, I do have one more question for Ms. Stotts.
Sure.
Ms. Stotts, the program you're saying you got accepted back into at Senate, is that inpatient or outpatient?
It's outpatient, IOP.
Okay. All right. Judge, and I think until that we get it verified, when is that supposed to start, Ms. Stotts?
I officially started, I did my intake yesterday and I have my first individual today at 2.
Okay. Judge, and we would still ask that another OSAR be done. I don't know if they're relying on the first. I don't think it's really understood how she got back in the program without doing one, but we would go ahead and ask that another one be completed also.
Ms. Stotts, who have you been talking with at Senecor? I mean, who sort of handled your?
My instructor, Leanne Moses, and the intake, I guess, director, her name is Connie. I don't know her last name. Because after my OSAR assessment, I spoke with Connie to do my intake. She's the one that I spoke to start Senecor. So she's the one that I spoke to re-enter Senecor.
Did you do it? Did you do another OSAR?
No, I've not done another OSAR.
Judge, her testimony was that after she was dismissed, she went back and asked to be placed back into the program.
Well,
and my insurance is covering it this time, not the state funding. The first one was state funded. I kind of, think that she's there. And I think as long as she remains in the program, I guess I don't really see the need for another OSAR. I'm willing to take another one if it's necessary.
I mean, I think it's a foregone conclusion what it's going to say, and you're already addressing it in intensive outpatient. So I'm not going to require she do another OSAR. I just, I'm going to require that she complete the program.
Yes, ma'am. Thank you.
Okay. All right then. Today then I'll continue the department as temporary managing conservator of all of the children. I'll find that Ms. Stotts and Mr. Shelton are complying with their service plans, but that there is a continuing and ongoing danger to return the children home at this point in time. We need to just keep making progress with services. Mr. Shelton, you need to really get going in earnest on things, because time, it sounds like a lot of time, but the dismissal date in this case is September 30th. And it's just amazing how fast that time goes by. So just get focused on getting these services done. We'll increase mother's visitation accordingly, if we can get the supervisory party in place to do that. And then I'll see everybody back July 9th of 2024 on a 9:00 docket. And that'll be our next review hearing. And we just continue the therapeutic visits with Indiana and just kind of see how that goes. Maybe just with a little time and a little more time with mom, that will work itself out. So not a totally unusual set of circumstances with kids this age. So, okay. All right. Thank you all very much. Best of luck to everybody.
Yep. I don't know if we addressed it. I believe Ms. Brown had mentioned about additional counseling sessions with mom on the parenting skills.
Miss Stotts, I want to approve that and get that in place for you. I mean, I think that might be beneficial, something that's very age appropriate to her. So I hate to burden you with more, but I think it's probably a good, I mean, with what we're dealing with, I don't think it can hurt.
Your Honor, Ms. Stotts 100% agrees with that.
I'll take
Can I ask a question?
Yes, ma'am.
If we're not able to have a 4-hour block in one day, is it okay to split the 4 hours in 2 different visits?
That transportation issue may be the problem.
That's what I was getting at when I said Friday and Saturday. I'm sorry.
Yeah. Well, because we use Choices Counseling, I don't know if they have a 4-hour window or if they even do visits on Saturdays.
But I think what she's saying, she could go Friday, do some time Friday, and then some on Saturday.
Yeah.
That's correct.
So because she's got a place to stay, so we could split it into 2 segments. If we can get 2 or 3 hours on Friday and then an hour Saturday, or 2 and 2, whatever that looks like.
Okay.
Okay. So we're just gonna have to look into it, Ms. Stotts, and see what we can come up with.
Thank you, Judge.
Okay. All right, I'll see everybody back in July.
Thank you.
All right, thank you.
All right.
Thank you,
Thank
Judge. This is
you.
my only hearing with this court today. May I be excused?
We're live streaming, and Ms. Taylor is making our record. All right, we'll take announcements.
Daniel Trout for the Texas Department of Family and Protective Services. Kane Williams is my permanency specialist. We're present at the end.
Jay Michelson on behalf of the mother, Nini Toon, and I don't see that she's present.
She's not in my waiting room.
Kenny Rojo on behalf of the child. And Judge, I don't know if Katsa is also in the waiting room.
They are. I just forgot to admit Ms. King. Okay, we'll get her in. Thank you. All right, Ms. King, we were calling the Wynn case, and so Ms. King is present on behalf of CASA. All right, then, what do we have new since the court report was filed? Other than it looks like some good news.
Nothing new. She's doing great in her placement right now.
Okay, and it also seems like maybe we're making some progress with mom as well.
Yes, she's working on counseling and working on getting signed up for parenting classes. And she met with everybody a few weeks ago, and she seems to be in a decent place for where we're at.
Okay. All right, then. Mr. Michelson?
Thank you, Your Honor. In reviewing the report, it looks like there's a couple of issues that Nini needs to address. One of them is, I believe, parenting classes, and the alternative was suggested as far as virtual visits go. And I noticed that it indicates that she has not submitted to a random drug test. I don't know if that's because the department has not asked her to do it, but I noticed that that's a requirement of her family service plan. And other than that, I have nothing to report. Sounds like she's doing pretty good.
Okay, Ms. Williams, have we requested her to drug screen?
We have not yet.
Just not a big concern in the case?
Correct.
Okay. All right, so she's in compliance with that?
Yes.
Okay. All right. Okay, and Mr. Wynn is not present. Have we had any further luck in contacting him?
No, ma'am.
No, ma'am.
Is he the one that we think is in the Thai Army?
Yes.
Yes, ma'am.
Okay. All right. Ms. Naranjo?
She is doing very well in placement. She's made some good progress. I know that they're working on their weight loss plan. I believe Nexus reported to us that she's lost about 10 pounds already. And I know when we met with everybody in person, CASA, St. Francis, Mom, and Nexus also did mention that they would have a transitional plan in mind for Mom to help her facilitate getting Pew home at some point, as well as we addressed concerns that Mom had reported to us that Medicaid had kind of denied doing any home health care for her, which Nexus said is unusual given that Pew has a diagnosis of Prader-Willis. So we discussed, I think, having a service coordinator be facilitated with Medicaid to try to get her some kind of home health care if when Pew is transferred home, because Pew will certainly need on time, 24-hour supervision, and mom can only do so much, and getting some medical services to help her will definitely help to ensure that we don't have to become involved again in the future.
Okay, and we have the resident expert with us this morning on those issues. Ms. Smith, do you foresee, I mean, you've been so instrumental in helping us with this child and placement. Do you foresee any problems moving forward with some additional home health?
I would have to look at her chart to see in the past why it was denied, if we have that. So I can't really guess if she would qualify. I do show that I think her stay at Nexus was denied, and they talked to the doctor there, and not sure if they're appealing that or not, but that was just a recent thing that came up yesterday that I see in the notes, due to her progress, that they don't think she's qualifies medically anymore. But as far as the home health, I would have to look. It would depend on the assessment by the people that assess her. So hopefully it would be approved.
So the goal is maybe to try to get approval to extend her stay at Nexus for a while. That's the first hurdle.
Yes, the superior doctor talked to the Nexus doctor about it. So I'm assuming Nexus might be appealing that.
Okay. All right. So we'll have to see how that plays out. And then the next hurdle would be whether we can get her approved for some sort of additional home health care if she's going to go home.
Yes.
Okay. Casa, anything to report today?
Thank you, Your Honor. Yes, we did meet with the CFE family team meeting, as Ms. Ronho and Kane and I all talked about. I think we have really came to a really good conclusion that yes, the aftercare services are going to be needed, but Miss Tyne is participating. She's very cooperative. She loves her child, and we just feel like there is some resources that we need to look into that will help her if she's reunified with Pew. Some of them are few and far between here in Amarillo. It just seems like she's going to need some support. And we wanted to make a connection for her as well, because she and Pew are already connected. We get that. But we are trying to ensure if she's reunified, what can we have in place for Pew and for Miss Tyne? Because if we don't have those in place, it won't be a successful reunification. So that's been a concern of Casa's. But the fact that we're all working together and having meetings and correspondence with one another, I feel pretty confident that some of these things can be in place. Plus, if Medicaid is willing to,
we lost the judge. Yeah, we lost the judge.
Ms. King, I'm going to just ask you kind of start over because I just heard the very first little bit of your report.
I think what I was saying, Your Honor, was that, we've all been in agreement with the fact that we've met with, CFE family team meeting. Miss Nunn is always participating. She's always been cooperative. She loves her child, but we're concerned about the resources that will be available for her if she's reunified with her mom. We want to make sure that they're in place, and especially if Medicaid can help us understand, what can be paid for, what do we need to do as a team. So things are progressing, yes, but I think that's one of my main concerns is what are we going to do if she's reunified with Mrs. Tyne? She's trying to work, and she really basically her goal and what she's expressed to me is that she wants to be able to be at home to take care of Pew 24/7. But we all know that she's gonna need some help with that as well.
Okay. Well, I guess we just try to check the boxes one at a time. All right, then for today, I'll continue the department as temporary managing conservator, and I'll continue Pew's placement. I'll find that mother certainly is in compliance with her service plan, and that there would be an ongoing danger to send the child home today, partially because we don't know what that would look like sitting here right now, and not necessarily because mother's not cooperating, but we just don't have maybe a full plan in place before we bring the child home. So I'll find the department's using reasonable efforts to reunify the family. And our next hearing will be July 9th, 2024.
She's frozen, but I know the rest of that sentence was, and that'll be on a 9 o'clock docket.
We're here today on a review hearing. We're conducting this through Zoom or live streaming, and Ms. Taylor is making our record. Okay, we'll take announcements.
Daniel Trout for the Texas Department of Family and Protective Services, Marissa Herrera is my maternity specialist. We're present ready.
Your Honor, I'm Tate Eldridge. I represent the mother, Ricky Armijo. I'm guessing she's one of these that's on the phone right here. I'm not positive though.
Mr. Hammonds.
Yeah, TD Hammonds for Ruben Pena. I'm ready to proceed, Judge. I've not talked to Ruben since we had our mediation, Judge, but I think we can announce to the court, you know, what we agreed to there, and I guess, you know, have a review hearing today.
J.C. Zavala on behalf of the kids.
All right, so just to be clear, Ms. Armijo nor Mr. Pena are present today, and I don't have them in my waiting room. So, all right then, I've seen what the mediated settlement agreement recites, and kind of that you all have come to some temporary agreements and have agreed to the extension in the case based on what I've reviewed in the court report and what I saw in the settlement agreement. I will grant the extension, find that there are extraordinary circumstances, and we'll set a new dismissal date. Mr. Trout, I don't know if you've had a chance to look at that, but.
Yes, ma'am. It would be September 20th of 2024.
Okay, set new dismissal date, September 20th of 2024. All right, then let's go ahead and have a review hearing and tell me what's new since the court report was filed.
Not a lot new. The parents did miss one of their virtual visits since the mediation took place. And then they did an in-person visit last week in Abilene. St. Francis transported them. Overall, they've provided the drug screens for the other adult child that lives in the home, and it was a negative UA and negative hair follicle on him. And we sent the parents to drug screen on Thursday, and they weren't able to go. And so they went on Friday. So those results are pending.
Children still doing well where they are. Sorry.
Was the reason given for not going a valid reason?
Mr. Pena had work on Thursday, and so they told me they would go on Friday.
Okay. All right, Mr. Trout, I'm sorry, go ahead.
I was just asking Ms. Herrera how the children were doing. They still doing great where they are?
Yes, they are. They're still with the same relative placement in Brownwood, and they're meeting all of their needs, medical, overall. Both children are doing very well.
I know we're doing a drug screen on the adult son living in the home. I believe at the mediation, we also discussed running background checks on him. Has that been done?
Yes, and it was a no hit, which means nothing came up.
Okay. I have nothing further then at this time.
Okay. All right. Are parents making any progress with attending medical appointments and, you know, learning about, in particular, Sophie's condition and medical necessities and that kind of thing?
When I talk to the parents, it's pretty known that they just want Samuel to come home, and so not a whole lot of efforts have been made to bridge that, just because they're not really wanting to pursue Sophie.
Okay. So long term, then, what's our plan with her?
The parents have expressed a willing to relinquish their parental rights for Sophie, but they just want Samuel to come home. But we still have some concerns, and we really want the children to stay together.
Okay. Anything else from St. Francis?
No, ma'am.
And Judge, that's where some of the conversation was going at the mediation, and to kind of see where this goes, and we may get back into a mediation again on this. Department would still like to keep the children together. They're in the family placement, so that's what's being in discussion right now.
Okay. All right, Mr. Eldridge, anything?
No, I could just everybody's kind of talked around this a little bit, but the child's got some really serious medical needs, and both the parents, and TD can correct me, but they're kind of on the same page in that she can provide better care for Sophie in particular than they're ever going to be able to. My client's on SSI. She's living on about $900 a month. They can't make the trips to Dallas or Cooks to do all these medical appointments and all that. And so they would love to have both kids home. They think Sophie is better off where she is, but they don't want to lose their entire family. They've done everything they've been asked to do in this case. They passed all the drug screens. And that's kind of where our mediation was. We had to suspend it because the older son is in the home. And my understanding is we're supposed to reconvene the mediation and then see kind of what we can do. But I just don't want to think my clients don't want Sophie back. They do. They're honest about it. They don't think they could take care of her the way she's being taken care of now. And that's our whole issue.
What relative has the children?
It's a relative on the maternal side. She's Ricky's sister's brother's family, but not Ricky's brother.
Yeah, it's kind of an extended branch of the family tree, Judge, but they are in contact and they have a good relationship. And even if the woman down in Dallas would adopt Sophie, just for the financial aspect that would help her with the medical and everything, she's very willing to keep the lines of communication open between Sophie and Samuel. And, they'd still be able to visit them on a regular basis and things of that nature. It's just, again, part of what, Tate and I discussed. These children are very young, Judge. I mean, Sophie is a year old. If they were 6, 7, 8 years old and, were very close, yes, I can understand St. Francis wanting to keep the children together. But this is a very unique situation in that Sophie, she has the brittle bone disease. She has some other issues going on. There was a notation, and in the report, and Ricky and Ruben both understand this, her life expectancy is 10 to 12 years. That's kind of what the doctors have expressed to them. She's going to have surgeries over the next few years. Sometimes they have appointments in Dallas 2 to 3 times a week. There's no way they can do that. And they're realistic about it. They love Sophie. They would like to have her up here, but realistically, it would be better for her to stay down there with this family member. So, that's where Tate and I are coming from.
So is the relative placement in the Dallas-Fort Worth area?
No, they're
an hour, 45 minutes to an hour away. Or
I thought, okay.
Brownwood, or is that
Brownwood?
Brownwood is what it
So they're 45 minutes out of Fort Worth area?
Yeah, certainly not 6 hours away like we are up here. And they do have limited income. I mean, Ruben has been working construction. I mean, everything from roofing to framing, And yes, Ricky, she had brain surgery 3 to 5 years ago, I think it was. So, I mean, she's dealing with some after effects of that.
My client can't drive, Your Honor. She can't drive a vehicle.
Right.
Yeah.
Okay, well, Ms. Zabala, what's your feeling about this? I mean, I understand maybe we've still got some concerns regarding Samuel going home, but we make a concentrated effort on that, and
well, I guess, Judge.
Otherwise, I mean, it seems like otherwise parents have done what we've asked them to do, and drug tests have remained negative, and we're just tacking on the 6 months. And I'm not taking back the extension. I don't mean that, because there are extraordinary circumstances with the one child's health problems. But are we spinning up into another 6-month cycle for something that could be resolved in the next 30 to 60 days?
Right.
So Ms. Zavala, what's your feeling about this?
Your Honor, both kids are thriving in the placement. It breaks my heart to think about separating them. But I mean, there are some good points being made about Sophie's medical needs and the completion for the parents. I think we weren't able to come to a resolution at the mediation due to just some unknowns about all of the people in the home.
Sure.
And it may be possible for us to get there now that we've got that information.
Okay. All right. Well, I know you all intend to go back, but I'm going to order you to go back to mediation, since this is just sort of a temporary arrangement.
Yes, ma'am.
But quite frankly, sooner better than later.
Well, and I guess, Judge, what you mentioned, the department has some concerns about Ruben and Ricky being able to take care of Samuel. I guess I would like to hear specifically what those are.
Fair question, Ms. Herrera.
I think whenever we explore reunification, there has to be a level of communication and cooperation from the parents. And with them not attending the virtual visits that are offered, they went months without any in-person visits. We would have to have them communicating with us. They're not communicating. I had to ask 4 times for their NA sheets just since February, and they just don't reply. And if Samuel was in the home, we wouldn't be able to confirm that he's safe if they're not responding and they're not cooperating.
Okay. Mr. Hammond, does that answer your question?
Judge, I will call Ruben, and I'm sure Mr. Eldridge will call Ricky, and we will tell them this is very important. But I can tell you, Judge, all of us have been doing this long enough that when the department walks into somebody's house and says, we plan to terminate your rights and we plan to keep both kids down south close to Dallas, and you're not going to have any children, that tends to throw a little wrench in the cooperation machine. And so when the department went in there and told them our first option is no longer reunification, we want to terminate you, when they have done everything they wanted them to do, they took that as kind of a slap in the face. And yes, it was natural for them to become cold shoulder. But I will stress to Ruben, they're going to have to warm up to them again.
Well, the bottom line is, I don't care how these people want to feel about one another, but the bottom line is everybody needs to be focused on what's best for the children. And this is one of those situations where what's best for one child may not be what's best for the other child. I mean, we have these situations where we've got very medically needy children, and their care cannot be addressed in our area, in our region. And we're forced to go downstate. Parents are forced to do that. We're forced to do it to get the best care for certain children that we can get. And I agree, it's very unfortunate anytime we have to look at sibling splits because of a medically fragile child, but we do it, and we have to do it at times, because what's good for the goose is not always good for the gander. I mean, it's just, we've got children with different needs. So I think we have to just.
I agree with you. Yeah, I agree with you, Judge. And again, from my perspective, Tate's perspective, we are not separating these children as if they will never have any contact with each other again. These people know each other. They get along. They cooperate. Ricky and Ruben appreciate the people down south. They do get very emotional when they realize they are not in a position to bring Sophie home. They would like to, but they're making the Solomon's decision of what's in the best interest of this child. And they're saying, we're willing to let her stay down there, but we want Samuel. There's no reason for us to give up Samuel.
Okay. So just, I think y'all have a conversation with them about cooperation and getting things turned in timely and returning phone calls or text messages. And, let's all get on board with what's in the best interest of both of these children.
Yes.
However that's going to look. So, I will order y'all back to mediation. So, okay. Anybody have anything further to report today?
No.
Nothing further, Judge.
Okay. All right, then I will continue the department as temporary managing conservator, and I'll continue the children's current placement. I'll find that there would be a continuing danger to return the children home today. Just we need to get some answers in place, and I think you're obviously part of your agreement. We're well on the way to getting some of those answers, so that's good. I'll find parents are in compliance with their service plans. And like I said, order you back to mediation. And then I'll see everybody back. Our next review hearing is scheduled for July 9th of 2024 on a 9:00 docket. And I know we put the case into extension, but I'm going to set that as the final, because I don't think things are going to change drastically between, July and September. I think we're going to be dealing with the same set of circumstances, unless parents completely fall off. But I'm going to set July 9th as the final in the case. If something happens and we're not ready, we can always push it back.
That's fine, Judge. I'm hopeful like you will get it resolved.
All right, then I'll see you ready for our final, July 9th, 2024, even though the dismissal date will not be till September 20th of 2024. Okay, thank y'all.
All right, thank
Jacqueline
you.
Roach. We are here today on a request for court-ordered services. We are conducting this through Zoom and we're live streaming. Ms. Taylor is making our record. All right, we'll go ahead and take announcements.
Todd Alvey on behalf of the Texas Department of Family and Protective Services. I'm present, ready to proceed, Your Honor. Ms. Lucero is here to testify if we need to. Prior to any testimony, I would ask that I be allowed to talk with Ms. Naranjo, Ms. Zavala in a breakout room so we see where I'm at.
Okay.
Naranjo for the mother, Jacqueline Roach. We are both present and ready to proceed, Your Honor.
Stacey Zavala on behalf of the child.
All right, thank you. Okay, let me get y'all set up. Ms. Naranjo, I suppose you'll need to have your client step out. All right, we got everybody out of the breakout room. Okay, Mr. Jeremy.
Thank you, Your Honor. I would call Elaine Lucero. And when did Family-Based Services start working with Ms. Roach?
Yeah. On December the 11th, I completed an assessment with Jacqueline.
And
for the transfer.
And at that time, was Ms. Roach cooperative with you in completing her assessment?
She did allow for us to come into the home. We did have a discussion with the entire family. There was some things that she kind of refused to talk about in terms of substance abuse, but she was cooperative in sitting with us.
And did you develop a plan in that assessment?
Yes, sir.
And were you able to discuss that with Ms. Roach?
Yes, sir.
And did she understand what you were going to be asking her to do?
Yes, sir.
What types of things were you asking her to do in that assessment?
We had asked for her, once we got the family plan in order, we had asked for her to complete counseling, an RBT class with Troy Timmons, substance abuse and parenting course that was online. We had requested for her to do an OSAR assessment. And then she currently has a psychiatrist. And so she was seeing that psychiatrist. We were just asking for her to follow up on her mental, for her mental health. We'd also asked for her to do random drug testing.
Now, What was your understanding of the reasons that FBS was working with Miss Roach?
Whenever investigations got involved, it was due to concerns of prescription abuse. At that point, we weren't sure exactly what prescriptions were being abused. We had been informed there were various prescriptions over a period of time that she had been taking, some prescribed, some were not. And so some of her behaviors while taking those prescriptions was the reason why we initially became involved.
And did those behaviors leave the children? Well, first of all, does Miss Roach have any children?
Yes. She has two, one of which turned 18 this month. And the other child is 13 years old.
And is it your understanding that her behaviors had left the children in dangerous circumstances?
Objection, Your Honor. Question calls for hearsay.
Well, if she's not testifying as to her personal knowledge, then I'll sustain.
Okay. Now, after your assessment, which you did on the 11th, on December 11th, did you ask Miss Roach to provide you with her prescriptions and the number of pills that she would have?
Yes, that's correct. I did do a pill count.
And when did you do that?
The first one that I did was on December the 15th. And then the second one that I did was on January the 17th.
And in that pill count and with her providing you with her prescriptions, did you find any concerns?
Yes, I did. Actually, prior to the December the 15th, I had explained to her that when I came out, I was going to need to see her prescriptions and be able to, make sure that she was on track with her regimen. And so when I did the initial one on December the 15th, a couple of her pill counts were fine. There was no issues with them. The one that we had concerns with were for her amphetamine pills. And those were short by 69 pills. And so at that time, she informed me that that half of the pills she kept at work. And I explained to her that moving forward, those pills needed to be in the home so that way I could count them. The next pill count that I did was January the 17th. And there again, the set of pills that were fine, the ketamine and hydroxy AM, I believe that's how you say it, there was no issues with those. But there again, we had concerns with the amphetamine prescription. And that at that point, there was none at the house. And then she informed me that she kept all of those at work. And so.
Now, Ms. Lucero, just to make clear, when you talked with her previously in December and January, you explained to her what about keeping her pills and her prescriptions?
That she needed to have them in the home. And when I came to the home for a visit, that I was going to need to be able to count those.
Okay. So when was the second count that you did?
The second count that I did was January the 17th.
Did you do a third count at any point in time?
I did not. At that point, but due to her drug screen, we started to have concerns with what pills she was taking and which ones she was not.
Did your concerns specifically relate to the use of the amphetamine pills?
Part of it was that her amphetamine pills weren't even coming across in her drug screens. And the other concern was that she had came back positive for Xanax, which she doesn't have a prescription for. And when I asked
Hearsay. She's talking about the results from the drug screen.
And then I'll cover that, Your Honor.
Well, I'll sustain as asked. All right.
Miss Lucero, did you talk with Miss Roach about her Xanax use?
Yes.
And what did she tell you about her Xanax use?
She explained she had one pill that she had taken. And when I asked for that bottle of prescription so that I could see, she said that she had thrown it away. So I've never been able to see that prescription bottle.
Had she provided you with a copy of the Xanax prescription prior to this discussion about Xanax?
No.
and you had asked for all of her prescriptions when you talked to her in December and January.
Yes, that's correct.
Were you aware that she had any Xanax in her house?
No, sir.
Under these particular circumstances, would that have been something that would have been important for you to know?
Yes, sir.
So she did admit that she used Xanax, but she was not able to provide you with any prescriptions or any bottles or anything showing that she had any.
That's correct.
And when did you have this conversation with her about Xanax?
I had spoke with her on March the 4th about her positive drug screen for Xanax.
On March 4th, other than the things we talked about her drug screens, did you have any other concerns about Miss Roach and her ability to parent her 13-year-old child?
I did have concerns after speaking with a counselor that we had referred her to. There was just continued concerns with her mental health and stability.
There's lack of personal knowledge and hearsay.
I'm sorry, Ms. Naranjo, will you say that again?
Objection to hearsay and lack of personal knowledge. She's saying what the counselors reported.
That's the same.
Did you talk with Miss Roach about her doctors?
Yes.
What doctors did she say she was going to?
Dr. Wynn.
Did you ask her at that point in time to provide a hair follicle drug screen?
Yes, sir.
Was she cooperative with doing that?
That's whenever the issues started in this case, is when we requested a hair follicle.
Okay.
And no, she was not cooperative.
Did she ever, the drug screen that she completed, what kind of drug screen was that?
Both of them were UAs.
Okay. Now, did she talk with you about using Delta 8 also?
Yes.
And did she provide you with a picture of a Delta 8 pipe?
Yes. Yes, sir, she did.
During the time from January through March, did Miss Roach complete any additional services that you were asking her to complete?
She did provide me, she did complete rational behavior training with Troy Timmons, the initial 6 sessions of counseling with her counselor. And then she provided me a certificate for an online substance abuse and parenting course.
During the time that you dealt with Miss Roach, do you believe that she was learning from those services that she was being provided?
Objection, Your Honor, calls for speculation. Also, she's not an expert witness to be able to qualify on whether or not she's made any improvement for mental health purposes or anything like that.
Your Honor, I'm not asking about mental health. She's FPS worker, and her job is to evaluate whether or not Ms. Roach is learning from services being provided.
All right. So the original question was, let's back up. Ms. Taylor, the original question was,
During the time that you dealt with Ms. Roach, do you believe that she was learning from those services that she was being provided?
okay. So as to the original question, I will sustain Ms. Naranjo's objection that it calls for speculation. I don't know that the question went beyond that, and it was asking, I don't think it was asking for her opinion about her improvement or lack thereof.
Ms. Lucero, as how long have you been an FBS worker?
Hold on, Mr. Jalvi, I think Judge is frozen.
No, I'm here.
Sorry, it was me then having technical difficulties. I apologize.
I've had problems this morning, so it could have been me.
Ms. Lucero, how long have you been an FBS specialist?
For about 5 years now.
And what is the job of an SBS specialist?
Our job is to make referrals out to community resources, follow up with those resources, professional counselors, psychiatrists, doctors, and get their input on whether or not we're seeing any behavioral changes. We also speak with relatives that live in the household, outside relatives as well, grandparents, aunts, uncles, people who have contact with our parents to ensure that there actually are behavioral changes taking place.
Is it part of your job to monitor the changes that are taking place during the time that a parent is working services?
Yes.
And were you monitoring Miss Roach's services and the changes that might come from the services while she was working the services for you?
Yes.
And did you determine if she was making any behavioral changes based upon the services that you were providing?
Objection again, Your Honor. That still calls for speculation, regardless of her position as a DPS worker. She can't speculate on whether or not she feels that someone's completed or done better.
All right, I'm going to deny the objection. I'm going to allow her to answer the question.
Yes, I did assess that, and there's continued concerns that there are not behavioral changes taking place.
Today, are you asking that Miss Roach be ordered to work some additional services?
Yes.
Has she been cooperative with you since March 4th?
She has allowed me to see the children, but her explanation moving forward is that she would meet with me when she felt like it, and that she'd no longer wanted me in her home. She was not going to give us a hair follicle. That's kind of her position that she has explained to me.
Are you requesting that she be ordered to complete some individual counseling?
Yes, we would like for that to continue.
And then do an OSAR evaluation and follow the recommendations?
Yes. And from my understanding early on in the case, she explained to me that she had completed one. I requested those records repeatedly and have not received anything. So if she has completed one, I'm asking that she sign a release of information so that I can obtain those records.
During the time that she is working services for FBS, are you asking that she be ordered to do random drug screens?
Yes.
You said that she was seeing a psychiatrist. Are you also requesting that she do follow up on any assessments done by a psychiatrist?
Yes.
And that you be allowed to see those?
Yes, sir.
And that the department be allowed into Miss Roach's home?
Yes, sir.
Are both boys still living at home with Miss Roach?
Yes, sir, that's correct.
The younger one are either boy in school at this time?
Both of them are still in school.
And were you, as an FBS worker, were there any services being provided to the boys during this from December through March?
We requested for them to be set up in counseling, and initially that wasn't I don't necessarily feel like it was approached by Miss Roach until recently. I have asked her to follow up with the therapist that she was seeing to get that scheduled. We've had payments sent over and everything for a while for them to both start counseling.
But I've only got one child, the subject of this suit.
That's correct, Joe. The other one's 18, so we didn't make. Okay.
But we're referring to, you've been referring to him as a child. So I just want to clarify for the record, there is a young adult in the home, but only one child. Okay.
Yes, sure. I'll pass the witness, Your Honor.
Okay. Mr. Ronho?
Thank you, Your Honor. Ms. Lucero, when you started the FBS services with Ms. Roach, she completed majority of the services requested of her, correct?
Yes.
And as far as the psychiatrist is concerned, Ms. Roach can follow up with her psychiatrist without a court order and without the assistance of the department, correct?
Yes.
Now, you reported that you visited the home, is that correct?
Yes.
And was the home deemed safe and appropriate for children?
Yes.
And you have seen the child, correct?
Yes.
And did you have any concerns about his well-being or his physical well-being?
As his emotional state.
But you're not qualified as a counselor or anything like that to give any commentary about his emotional state, correct?
I'm not a counselor, no.
But physically, he appeared to be fine.
Yes, physically.
I'll pass away.
Okay, and Ms. Zavala?
Ms. Lucero, it looks like somewhere in the beginning of this case, a safety plan was put into place.
There was a safety plan during the actual investigation, not necessarily during my case, not during the family base.
The 13-year-old Jagger, who drives him to school and to doctor's appointments whenever he needs?
I believe it's majority of it is Jacqueline.
I'm sorry?
Jacqueline, his mom.
Okay.
From my understanding, we haven't really had that discussion, but I'm guessing it's her.
Are there concerns based on the pill count and the schedule that there's the possibility she's driving under the influence with her child?
Objection, Your Honor, calls for speculation.
Overall, I mean, it's just, she just asked if there was a concern about it, not that it was happening, just if there was a concern.
I would say that there would be a concern.
At any point, was a plan put in place so that someone other than Miss Roach would be responsible for driving Jagger?
I believe during the investigation, there was a safety plan put in place where there was like a supervising party, somebody kind of monitoring, coming in, seeing how things were going in the home.
But ultimately, that safety plan didn't work?
Yes, that fell through.
You mentioned that at some point you met with the whole family. Who did that include?
That include Jacqueline, her spouse, Chase, and her two kids, Jason and Jagger, and the investigator.
Okay. And at that point, Jason was, I don't know if I've got the name correct. Is the oldest now young adult named Jason?
Drayson.
I'm sorry, I'm having trouble hearing.
It's Drayson, Dreysn.
Okay, okay. Was he still under 18 at that point?
Yes.
In your conversations with Jagger and Drayson, at any point, did they make any kind of outcry of abuse or neglect?
Objection, Your Honor, calls for hearsay.
Overruled, it's a outcry.
Your Honor, I believe for the exception for an outcry for a child for hearsay, the child has to be under the age of 12. And I believe both these children are over that age.
All right, Ms. Zavala, any response?
Not at this time, Your Honor.
Okay, any further questions?
At any point, did you observe anything that you felt put Jagger in danger?
Concerns of what's been going on in the home behaviorally, information that I've received from the counselor, concerns with both of the kids, mental and emotional well-being.
This is all information that she received from other persons as well as hearsay.
Sustained.
I pass witness.
All right, Mr. Albee?
No further questions of the witness, Your Honor.
Okay, Ms. Naranjo, do you have any further questions?
No, Your Honor.
Okay, Ms. Zavala, anything else?
No, Your Honor.
All right, Mr. Abbey?
I'll call Ms. Roach, Your Honor. Ms. Roach, in October of 2023, did you go to sleep, pass out with the burner on your stove, with the gas on, but the burner not lit?
Yes, not on purpose.
And I didn't ask you if it was on purpose. I just asked if you did it. Okay. Did your ex-husband come in and find the burner like that? They may be frozen, Your Honor.
Yep. I think.
Ms. Roach, do you have an answer for that question?
Oh, no.
All right. So the incident where you were asleep and the gas was burning on your burner or on your stove took place during the time when your children were at school, correct?
Yes.
All right. And is Chase Roach your current husband?
Yes.
All right. He brought the boys home from school and found you like that, correct?
Yes.
Okay. And you became angry with him when he woke you up.
Yeah.
And you and he began a fight.
Yeah. I mean, little argument.
Okay. And did you hit him with a clothes hamper?
No. No.
And later, when he left, did he leave after that?
I don't know.
Did he come home and did he find you in the backyard hitting your TV with something?
No, sir.
Later that evening, when he was cooking on the grill, did you throw something through the glass window?
Yes.
Were you still under the influence of your prescription pills at that time?
No.
In November, when the department was following up on these incidents, did you talk to and tell a department representative that you were prescribed Adderall and Seroquel?
Yes.
Are you still prescribed Adderall and Seroquel?
Yes.
Is this incident with the stove burner with the gas on, is that the first time that has happened?
Yes.
Has it ever happened before?
Never.
Did you tell the worker that you had gone into fight or flight mode and that's the reason you were angry with Chase?
Yeah, because I got woken up.
Did you also tell the workers that you used marijuana?
I used Delta 9 or Delta.
Okay. And you understand that Delta 8 or Delta 9 has a depressive effect on your system?
No.
Have you talked with your psychiatrist about the interactions between your use of Delta 8 and the Seroquel and Adderall that you were prescribed?
Yes.
And you feel comfortable continuing doing that?
Mm-hmm.
I'm sorry?
Yes.
When was your first car accident?
Objection, Your Honor. I object to relevancy here. I don't see how a car accident has to do with anything or when she had a first car accident.
If you'll give me just a little bit, Judge, I'll get to tied in.
I'm going to overrule the objection. I'm going to give him a little bit of leeway.
My first car accident?
Yes, ma'am.
Um, it was, I mean, back in my 20s, I believe.
Okay. Did you have one just after you married Chase?
Yes.
Was it pretty serious?
Yes, the lady ran a stop sign and
And were you prescribed medications for that?
no, sir.
Have you been using unprescribed medications since that date?
No, sir.
Have you had numerous car accidents since that accident?
No, I'm not at fault.
I didn't ask that, ma'am. I asked you, you've had numerous car accidents since the accident you had after that the lady ran the stop sign.
Mm-hmm.
How many?
I think there have been 2 or 3 that have not been my fault.
Okay. When was the accident that took place right after you married Chase? Do you remember what year?
2018.
Okay. So you've had 3 to 4 car accidents since 2018.
Yes, that are not at fault.
Again, ma'am, I'm not asking you if they're at fault. I'm just asking if you had them. In December, did you have a conversation with Miss Lucero about and do an assessment with her about FBS services?
Yes.
And were you agreeable to working those FBS services in December of 2023?
Yes.
And at that point in time, do you recall Miss Lucero telling you that she needed to have all of your prescriptions so that she could monitor your drug usage?
No, she never stated that.
Did she ask for your prescriptions?
She did.
Okay. Did you provide her with a Xanax prescription?
No, I didn't know I still had it.
But you used it at a later date during the time when she was monitoring you.
Yes.
Was it a current prescription?
It was one that I had been prescribed, yes.
That's not the question I asked, Miss Roach. Was it a current prescription?
No, sir.
When Miss Lucero asked you for for pill counts on December the 15th, did you provide those pill counts to her?
Yes.
And did Miss Lucero explain that you needed to make sure you had your prescriptions at the house so that she could monitor those pill counts?
No, she never said anything about monitoring my pills.
Did she count your pills again on January the 17th?
Yes.
And did you tell her that you left your prescription for the Adderall or the amphetamine at your work?
Yes.
Are you opposed today to continuing counseling, Miss Roach?
Yes.
You don't think you need any more counseling?
No.
And are you still using the same prescriptions for Adderall and Seroquel?
Yes, sir.
Do you have any other prescriptions?
One other one that's it's an anxiety visceral.
Do you know what that does?
It's an antihistamine.
It's an antihistamine for anxiety?
Yes, that's what Dr. Wynn prescribed because he didn't want to put me on a controlled substance, another one.
Are you still using Delta 8 on a daily basis?
No.
How often do you use your Delta 8?
Maybe once a week.
Do you think that it affects your medications? Do you think that they affect your ability to think clearly?
No.
Do you think that you're capable of monitoring your children?
Absolutely, yes.
And you think passing out while your gas burner is on is an appropriate way to monitor your children?
No.
If your children had been at the house that day, do you think that would have put them in danger?
Action, Your Honor, calls for speculation.
I'm asking her opinion, Your Honor.
No. Overruled. You can answer the question.
No.
I'll pass the witness, Your Honor.
All right, Mr. Ron, have any further questions?
Yes, Your Honor. Ms. Roach, you completed 6 sessions of counseling, correct?
Yes.
And you also completed the rational behavior training with Troy Timmons, correct?
Yes.
And you also completed a 12-hour online substance abuse and parenting course, correct?
Yes.
And are you currently following up with your psychiatrist, Dr. Nguyen?
Yes.
Do you have any recent appointments scheduled with Dr. Nguyen?
In a month.
And how often do you follow up with Dr. Nguyen?
I see him every 2 months now.
And you've been following all of his recommendations?
Yes.
And from the services that you have completed, what have you learned from those services?
I've learned quite a bit. Things that I didn't know that I needed to learn.
Can you explain a little bit more detail?
Troy was great. The class was great with Troy Timmons. I was one of the ones that was engaging in the class a lot more than some of the others. And the anger that I learned to help control the anger, I highly recommend his class. It was fantastic. And then the substance abuse and parenting class, a lot of the things I could have answered myself. I mean, I just went along and absorbed the information, whether it was stuff I already knew or stuff that I've already been doing to help, or things that I need to do as far as really it's just the anger. And yeah, I learned a lot.
And the incident involving the gas burner, was that a one-time incident?
Yes.
And it was not intentional, correct?
No.
Do you feel that your children are safe with you?
Absolutely, yes.
And regarding the incident about the throwing the thing through the window, was there basically an argument between you and your husband?
Yes.
And do you feel that that's outside of this CPS case?
Yes.
And that you and your husband have personal issues that you two need to work through?
Yes.
Now, are you requesting today that you not be court ordered to do any services?
Yes, I am.
I'll pass the witness.
All right, and Ms. Zavala?
Ms. Roach, if I understood correctly, you're currently taking Adderall, Seroquel, an antihistamine, Delta 8 once a week, and then you used some Xanax recently?
Yes.
Okay. What restrictions do any of those medications have about driving while you're taking them?
None of them.
None of them have the warning about operating heavy machinery, driving. You can take those at any point and drive at any point.
Yes.
Okay. You're meeting with Dr. Nguyen every 2 months?
Yes.
Okay. What did he say when you told him that you added back in the Xanax?
Objection, Your Honor, calls for hearsay.
Sustained.
Did you tell him that you added back in the old prescription of Xanax on top of what you're already taking?
Yes.
Okay. And did he authorize that use?
Objection, Your Honor, calls for hearsay.
Are you still adding that Xanax to what you're taking now?
No.
Did you tell him that you're, in addition to the prescription medication, that you're also doing the Delta 8 once a week?
Yes.
And who is it that takes Jagger to school?
His brother.
Okay. And who picks him up?
His brother.
And who takes him to extracurricular activities?
It's between me and his brother.
Was there ever a time where you felt like your medication mix was off?
No.
Was Jagger present when you broke the window?
No.
Where was he?
I believe at a friend's.
Do you believe that if he had seen that would be difficult on his emotional state?
Objection, Your Honor, calls for speculation.
Overruled. I'm going to allow his mother to answer that question.
No,
Is it normal for him to see you throw something through a window?
no,
So you don't think that would be disturbing to him to see?
they're very understanding about what's going on with me and my husband.
Did you break a door in the home previously?
No,
Why is it that you refused a hair follicle?
I was exercising my rights and refusal.
If you were to take a hair follicle, what do you think it would show?
Exactly what I've told y'all.
Which is?
My medications and the one-time Xanax.
That's what it is.
You may have further questions for this witness.
Yes, just a couple, Your Honor.
Okay.
Ms. Roach, did you tear up your Christmas tree over Christmas?
No, no, sir.
Did you you had any conversations? And I don't know what those conversations, I don't want you to tell me what was in those conversations. Have you had conversations with your counselors or counselors at the school about your children?
No,
Any concerns about the welfare of your children at this time?
no,
And even though you guys are fighting and arguing, the boys are pretty good with it. Is that what your testimony is?
I mean, me and my husband are on the verge of divorce, so things in our home aren't exactly calm.
That wasn't my question. My question, Ms. Roach, is are the boys okay with it?
No,
And you don't think that they deserve to have some service?
no.
Pass it.
Okay. Ms. Ronho?
Just briefly, Your Honor, to clarify for Mr. Alvey's question, when you say that the boys are not okay, do you mean not okay with you proceeding with a divorce against your husband?
Yes, I mean they're not happy about things, but it is what it is.
But other than that, they're physically and emotionally okay in your opinion?
Yes. Yes.
Now, regarding the amphetamine pills that you have, are they Adderall?
Yes.
And do you keep your Adderall at work?
I do.
Why do you keep it at work?
Because it's the less chance that I can take it at home when I'm not supposed to, and I only take it when I'm at work. Never mind.
Is it to help you focus at work?
Mm-hmm.
I'll pass the witness.
All right. And Ms. Vala, anything further?
No, Your Honor.
Okay. Okay. Anybody have any intentions of calling any other witnesses?
No, Your Honor, I rest.
Okay, Ms. Ronho? Okay, Ms. Naranjo, any further witnesses? All right, we'll try again. Ms. Naranjo, you have any further witnesses to call?
No, Your Honor.
Do you rest?
Yes, Your Honor.
Okay, Ms. Zavala, do you rest?
Yes, Your Honor.
Okay, Ms. Zavala, do you have a recommendation?
Your Honor, I am concerned, especially regarding the pill count and issues regarding the alleged anger and destruction. My biggest concern would be who's driving Jagger around. However, I don't know if we've fully gotten there in terms of the issue of danger. I can't imagine it's a good situation for him to be in. I am very concerned about what he's witnessing and the potential for him to be involved in a situation where someone's driving him who should not. I do think that services would be helpful to the family, and would love to see Ms. Roach continue to participate in those.
All right. So, and I just want to make sure we've still got Ms. Ronho and her client. Let me know if you don't get any of this. All right. Okay. Well, what we're going to do today is I'm going to sign an order from mom to participate, but basically what we're going to do is I'm going to order her to provide her prescriptions for any medications she has taken in the last 90 days. And that needs to be from her physician's office, whoever those physicians may be. But it needs to be a list that would identify anything that she has been given a prescription for and taken in the last 90 days. And then I'm going to order her to submit to another UA and to a hair screen today before 4 p.m. Once we get the results of those, if it's negative for any substance other than what she has a valid prescription, then the case will be dismissed. If it shows positive for anything other than her valid prescriptions, then the case will continue, and I will order that she would submit to an OSAR and any recommendations out of that OSAR screening, random drug testing, access to home and the children, and counseling for the children. Ms. Roach has already done some counseling. She's expressed she doesn't wish to go back to counseling.
I'm sorry, Judge, my cutting out again.
I don't know where you may have lost me.
The last I heard was that if she's negative for substances, all substances that she doesn't otherwise have a prescription for, then the case will be dismissed.
Okay. If she is positive for anything other than what she has valid prescriptions for, then the case will continue and she will be ordered to submit to an OSAR screening and any recommendations that come out of that, random drug testing, access to the home and children, and counseling for the children. She has been to 6 sessions of counseling. She's expressed she doesn't think she needs to go back. I think we all know if she's not willing to do the counseling, that's just going to be a big waste of time. So if any time she does want to return to counseling, that would be great, obviously. So I will sign an order based on those things. So it kind of all hinges on this drug test. So we need to be sure that paperwork is, Ms. Lucero, that paperwork is over at Care Express quickly so that she can be there before 4 p.m. today.
Yes, ma'am, I'm working on getting that.
Ms. Roach, it's important for you to know failure to give that drug screen is deemed a positive result. And then, by default, this case will continue. My big concern is if there's use of prescription drugs that's not authorized or that's not in line with what you should be doing. Otherwise, I think a lot of these issues are going to be addressed in your divorce case, quite frankly. So, let's just get over the big hurdle of do we have a problem with prescription pills or not? And if not, then we're out of it. All right. Appreciate everybody. Thank y'all. And I assume the department will get me an order and then someone will let me know whether it's time to dismiss her. Okay, thank y'all so much. We're today's scheduled for our final. We are conducting this through Zoom under finding good cause and agreement of the parties. We're live streaming, and Ms. Taylor's making our record. All right, we'll take announcements.
Daniel Trout for the Texas Department of Family and Protective Services, present, ready on.
Joel Jackson on behalf of Mother Brittany Chenault. I'm present. My client is not, Your Honor.
And Judge Natalie didn't make it back in.
Oh, correct. Let me get to her.
Okay.
Okay, if you want to go ahead and announce.
Okay, Natalie Archer for the father, Logan Cooper.
Stacey Zavala on behalf of Hadley.
Okay. Mr. Trout, who are your first witnesses?
Haley Jordan, and I'll be calling Tasia McIntyre too if you want to swear both in already. Good. Hey, Ms. Jordan, how are you employed?
I'm a supervisor with the Department of Family and Protective Services.
And in a case that the department's involved with, does the department keep regular records of its cases?
Yes, sir.
And are those records kept in ordinary course of business?
Yes, sir.
And are those entries in the records made at or around the time the events occurred?
Yes, sir.
Are the entries made by a person with personal knowledge?
Yes, sir.
Do you have access to those records?
I do.
Are you a custodian of record for the department?
Yes, sir.
Have you had the opportunity to review the records involving in the case?
Yes, I have.
Are the removal affidavit and the investigative reports, are they made part of those records?
Yes, they are.
And are they filed with the court?
Yes, sir.
And have you reviewed those documents?
Yes, I have.
And you were not the original investigator on this case or the supervisor. Those two people are no longer with the department. Is that correct?
Yes, sir.
But prior to this case, you'd had dealings with the mother, in this case, Brittany Chenault, before. Is that correct?
Yes, sir.
How did the department become involved in the case involving Hadley?
On March 10th, 2023, we received a report stating that Ms. Chenault had given birth to Hadley and that Ms. Chenault had tested positive for methamphetamine on a urinalysis during birth.
Did the investigator at the time, was he able to see the baby?
Yes, he was.
And was that in the hospital?
Yes, it was.
Was the baby having to be fed by a tube at that time?
Yes, she was.
And it was again noted that baby and mom and baby had tested positive on UAs?
Actually, just mother tested positive.
That's great. Okay. Was the investigator able to work with the mother or speak with the mother?
He did.
And what was the mother's name?
Her name is Miss Brittany Chenault.
Okay. And did they discuss the mom's drug screen with her?
Yes.
And did mother admit to it or deny use at that time?
She denied use.
On March 13th, did the investigator at the time ask mom to go drug screen?
Yes, he did.
Did she go drug screen that day?
No, she did not.
Did mom mention why she didn't drug screen?
She said that she didn't, without a court order, she was not going to do so.
Did mom say who possible dad was in this case?
She denied having knowledge of who the father was.
Okay. Did the department at the time suspect who dad would be?
Yes.
And who was that?
Mr. Logan Cooper.
Mom was she still married at the time, legally married at the time?
Yes.
And why did the department suspect Logan Cooper?
She had been in a long-term relationship with him, and grandmother, Brittany's mother, can't say her first name. She actually had reported to the department that it was a possibility.
Okay. Had mother had cases prior to this?
Yes, sir.
And were you involved in that prior case?
I was.
Do you know the outcome of the prior case?
Yes, sir. I actually was the investigator on that case and had removed Ms. Chenault's twins.
Okay. What was the final outcome in that case? Were mom rights
What do you mean?
terminated on that case?
Yes.
Judge, I'd ask to admit exhibit number 4. It's the certified copy of the final order terminating parental rights of Ms. Chenault as to her twins. And they were terminated on grounds of D, E, N, and O.
Objection.
No objection.
No objection.
All right, petitioner's exhibits will be admitted.
Ms. Jordan, did the department ask for to remove the child by court order?
Yes, sir.
And that was due to mom's drug screen while giving birth and mom's refusal at the time to give drug screen for the department and concerns of drug use due to prior history.
Yes, sir.
And was that removal granted?
Yes, sir, it was.
Do you know, was after the removal, did mom drug screen for the department?
No, she did not.
So as far as you know, while your case was pending, you don't know if she drug screened?
No, sir.
Were you able to was anybody able to make contact with Logan Cooper?
Yes, on March 22nd, 2023.
And where was he?
He was detained in Potter County.
Okay. Did he mention that he may or may not be father?
He said that it was possible that he was the father.
Okay. Do you know what he was incarcerated for at that time? It's okay if you don't. I just wasn't sure if you did.
I actually don't have that knowledge.
Did the department just believe that it was in the best interest of the child to remove due to the child having to be fed by tube while it's in the hospital in the NICU? The positive drug screens from mom at birth of the child and past history, including mom's prior terminations.
Yes, sir.
And do you know where the child was placed?
She was placed in foster care immediately after the removal.
Okay. During conversations with mom, did she state her prior case, her lack of cooperation in her prior case wouldn't happen again?
She did.
And that she would do what she could to get her child back?
Yes, sir.
Were we ever able to speak to at the time, I believe his name is Zachary Chenault, who was legally married to mom?
During hold on, let me make sure I'm not gonna.
Yes, ma'am.
No, we were not during the open investigation.
Okay. In the investigative report on March 21st, did the investigator call Zachary and inform him of the case?
A diligent search. Oh, sorry about that. Yeah, on March 21st. Okay. 2023, the investigator did speak with Zachary Chenault and informed him of the open case and the baby.
Was the baby on oxygen while in the hospital?
Yes.
And I know there was mention, was the baby released with oxygen or was it taken off oxygen before she was released? Do you remember?
She was taken off before she was discharged.
But while in the hospital, due to some complications, had to be fed by a tube and was on oxygen. Is that correct?
Yes, sir.
And again, department did feel it was in the best interest of the child to remove.
Yes, sir.
I'll pass the witness, Sharon.
All right, Mr. Jackson.
Thank you, Judge. Ma'am, when is the last time you had contact with Miss Janal?
The investigator in this case had his last contact with her on, it looked like it was a text message between the two of them. Well, actually, no, on March 16, 2023, he had attempted to locate her and had contact via text on March 16th, 2023.
From what you're looking at there in your system, does that appear that that's the last contact that the department has had with Ms. Janal?
He spoke with her after the orders were granted on March 21st and went over the paperwork and those type of things with her on March 21st at the department.
Okay, do you have the report that was filed with the court?
The investigative report?
No, ma'am, the permanency report to the court for this hearing?
No, sir.
Okay, I'll pass the witness, Your Honor.
All right, Ms. Archer?
Hi, am I unmuted?
Yes, you are.
Okay. You mentioned speaking to Logan Cooper in March of 23 and him saying he was the possible father. Was genetic testing done after that time?
I don't have knowledge as to whether that was done or not.
And do you know was that the only time that you were able to speak to Logan Cooper, or did someone from the department reach him afterwards, after March 23?
The investigator's last contact was on March 23rd. After that, the investigation closed, and therefore I can't answer that question.
I understand. Thank you. I no further questions.
And Ms. Zavola?
No questions, Your Honor.
Okay, Mr. Trout?
No further questions of this witness, Your Honor.
All right, counsel, any objection for Ms. Durant to be released at this time?
No objection.
No objection.
No objection.
Objection.
All right, Ms. Durant, thank you very much for your time today. You are free to go.
And how are you familiar with that case?
I've been the case manager since it was handed over to St. Francis.
When you first get a case, what is your first steps you do?
Review the investigation, also meet with investigation, and then start trying to meet with parents and go from there.
Were you able to meet with Brittany?
I was.
Did mother ever go drug screen for you at the beginning of the case?
She did in the beginning.
In the very beginning. Judge, I'd ask to admit exhibit number 1. It is the affidavit of business records that was filed with the court prior to the hearing involving the drug screens.
Any objection, counsel?
No objection.
No objection.
I just needed to clarify, Mr. Trout, are these the records of the Alcohol and Drug Testing Service Incorporated?
Yes, sir.
Okay, Your Honor, I'm going to object to these being submitted into evidence. They were submitting for filing on March the 5th of 2024, and that is at 2:01 p.m. that afternoon. So I'm objecting on the basis that it hadn't been timely filed. We're 22 hours into the 13th day. I know it's a technicality, but that's the objection that I'm formulating. Technically, the 14th day would begin at 2:29 this afternoon. And that's my objection.
All right, Mr. Trout, any response?
I can't argue with that. They are file stamped at 2:29. They were filed essentially 14 days ago, but not to the minute, Your Honor.
And
well, what's the rule read? Does it say anything about hours and minutes?
It says 14 days prior to the final hearing or trial, I believe is what it says, Your Honor.
I don't think it says anything about hours and minutes, but I think that we can all agree that a day constitutes 24 hours.
Well, but the question is, were they filed on the 14th? Were they filed 14 days in advance of today?
It was filed on the 5th. 14 days from the 5th would be the 19th.
Would be today.
All right, I'm going to overrule the objection, and I'm going to allow them based on the fact that the rule just refers to 14 days in advance, and so I'm going to find that they were filed 14 days in advance, maybe not to the exact minute or time, but I don't think the rule addresses that. So
Yes, ma'am.
Okay. So exhibit one's admitted.
Thank you, Judge. Ms. McIntyre, did mom test positive on any drug screens at the beginning of the case?
She tested positive on a hair follicle April 25th, 2023.
Okay. So shortly, about 2 weeks after removal?
That's correct.
During the course of your case, did mom regularly drug screen for you?
She did in the beginning, and then we started falling off and failed to appear as directed starting in October.
Okay. When was the last time mom drug screened for you?
Her last drug screen for me was a UA and hair follicle on September 12th, and they both came back negative.
But that's been 5 months ago at least?
That's correct.
6 months. When was the last time you had contact with mother?
Last contact with mom was November 7th, 2023. I attempted a home visit and she told me she couldn't meet with me that day, then texted me and went ghost after that.
Okay. Was your appointment to go visit with her, was that set up voicemail or did you speak to her or was that all through text message?
I did speak to her face to face and she said that she could not meet with me at that time when I showed up at her house.
Okay. And you have not heard from her since?
That's correct.
How often do you try to get in touch with her?
3 times a month. We have to.
Okay. Have you spoken to, I know her mother they talked to her mother during investigations. Have you been able to talk to her to see where mom may be?
I have had no communication with maternal grandma.
Okay. Have you had any contact with any family members that could tell you possibly where she is?
No, sir.
And what do you do to try to, when you have a parent quit communicating, what do you do to try to find them?
I send texts multiple times a month saying, hey, I need to meet with you this month. When is your schedule good? When can I meet with you? Trying to make it accommodating. Also do unannounced visits because I'm unable to get a hold of them, as well as drive by frequent places that I know that in the past she has told me she's been at.
Okay. Do you run any searches to see if new numbers pop up or anything like that? Or
we did searches in the beginning, but her home address has not changed. Her vehicle is out front every time I go knock on her front door.
Okay. All right. So as far as you know, the information you still have is the correct information for her.
That's correct.
And you've not found anything or been told anything different?
No, sir.
Okay. What else do you do when you first get a case? You meet with the parents and then where do you go from there?
So I speak to the parents to see what they feel like they need to work on to get their child back. We develop a family plan of service. We go over that family plan of service and they sign that and we start services.
Okay. Change direction real quick. I know the question was asked earlier of the investigator. Was a paternity test ever done on Logan Cooper?
Yes.
And was he in prior hearing been adjudicated to be dad?
That is correct.
Judge, I'd ask to take judicial notice of the confirmation of the paternity test on Logan Cooper that was filed with the court on 6/21 of 23, confirming that he was not excluded as a father. And Judge, I believe also that we adjudicated him as father per the docket entry on 9/12 of 23.
Correct. We did.
Thank you. Ms. McIntyre, do you said you do service plans, is that correct?
That's correct.
And what do those service plans involve?
The services that they need to work on to be a better parent and get their kid back in their home.
Okay. And did you do that for Brittany Chenault?
I did.
And were those filed with the court?
It was.
Did you go over those with her?
Yes, I did.
Did she sign them?
Yes, she did.
Judge, I'd ask to admit exhibit number 2, which is a signed family plan of service for Brittany Chenault that was filed on 4/27 of 23. And Ms. McIntyre, was that made in order of the court?
That it was.
Judge, excuse me, Tasia, did you do a family plan of service for Logan Cooper also?
I did.
And have you ever been able to meet with him?
I did.
And did you let him know about the service plans?
Yes, and he signed it with me in Potter County Jail.
Okay. Judge, I would ask also to admit exhibit number 3, which is the family plan of service for Logan Cooper that was filed with the court on 5/12 of 23. As to Dad Logan Cooper, has he ever worked any services?
No, sir.
When was your last contact with him?
May 12th, 2023 in Potter County Jail, the day we signed the family plan of service.
Okay. Do you know where he is since then?
I've had communication with his mother. And I also know when he was released from ISF, but he has refused to have communication with me.
Okay. And you said he was, what was he in jail for when you first met with him?
probation violation, and he was waiting to pull chain because he was sentenced to ISF for probation.
Okay. Judge, I would ask to admit exhibit number 5, which is the indictment for an ag assault with a deadly weapon against Logan Cooper, and the victim was Brittany Chenault. I would also ask to admit exhibit number 6, which is the judgment for that charge, in which he was given 10 years of supervision as probation, Your Honor. Exhibit number 7, certified copy of the supplemental order amending conditions. On that order, it also, as under number 104, states that Mr. Logan should have no contact with Brittany Chenault. And then, Judge, exhibit number 8 is a motion to revoke community supervision against Mr. Logan Cooper. This was filed on January 11th of 2022, and it's a certified copy. Judge, exhibit number 9, certified copy of the order on the motion to proceed that sent Mr. Cooper to ISF that Mr. McIntyre was just speaking of. Finally, in this group, Your Honor, exhibit number 10, which is a motion to revoke supervision. Mr. Cooper still on probation for this charge, and they have, as recently as January 22nd of 2024, have filed another motion to revoke his community supervision. Thank you, Your Honor. Ms. McIntyre, you said your last communication with him was May of last year?
That's correct.
And he's never reached out to try to work get services started?
He would talk through Brittany or talk through his mom, but he would not directly speak with me.
Okay. Did he ever set up any services?
Not to my knowledge.
Did he ever receive any visitations with that?
No.
Has he reached out to you personally or tried to get any visitation set up?
No, sir.
Do you believe it is in the best interest of Hadley to terminate Logan Cooper's parental rights based upon failure to work services, constructive abandonment? Those are our main grounds for terminating his parental rights?
Absolutely.
And do you believe that is in the best interest of the child?
Definitely.
As to mom, what services did mom work? How did she do through the case?
So mom started out really good until dad got released from ISF. She started her visits, started doing visitations. She also completed 4 sessions of parenting class, had to restart them and never restarted them, but she did start them in the beginning. She was tested negative. She would schedule her OSAR, but never completed it. And she started individual counseling as well as a psychosocial.
Okay. What services did she not complete?
She did not complete parenting, negative drug screening, rational behavior therapy, and OSAR, visitations with her child, as well as a steady employment.
Okay. And again, you said you're in communication with you said your last communication was September, October?
November 7th.
November, sorry. Okay. And when was her last visitation with the child?
Her last visitation, May 31st. Oh, wait, no, so they were canceled by me due to mom continuing to cancel. Judge Baker reinstated them in September. She had 1 visit after September, and then they were suspended once again.
Okay. And was part of the last suspension on missing a UA and missing her OSAR vow?
That's correct.
Okay. Were you ever able to communicate with her she needed to get these things straightened out to reinstate visitations?
Through text messages and also a few phone calls. She was pretty upset with me. Didn't understand why she couldn't see her daughter just because she wasn't attending her drug screens.
Is the department asking today for termination of the parental rights of Brittany Chenault as to Hadley Smith, one based on prior termination under the D and E grounds?
Yes.
In a prior case, failure to complete her services?
Yes.
D and E grounds while using testing positive at the birth of the child?
Yes.
And constructive abandonment at this time?
Yes, sir.
Do you believe that's in the best interest of the child?
Definitely.
Where's the child right now?
She is placed in a foster home in Childress, Texas.
Okay. Is this a long-term placement or what are we looking at on this placement?
Hadley has been in her intended to be permanent placement.
Okay. So these people are wanting to foster family right now is wanting to adopt.
That's correct.
Okay. Are they already licensed or do we have to go through that process?
They are already licensed.
Okay. So they are just waiting to see where this goes.
That's correct.
Okay. And you do believe that termination of both parents' rights is within the child's best interest?
Yes, I do.
I'll pass the witness, Your Honor.
Okay, Mr. Trout, with respect to the M grounds, let's talk about that.
Okay.
Would you agree that that prior termination order was signed on June 1st of 2021?
Yes, ma'am, I believe so. And filed 7th of 2021.
And this petition was filed March 21st of 2023.
Correct, Your Honor.
And to invoke that subsection.
I believe it's outside the 12-month range, I believe, Your Honor.
Okay, just want to make sure we're all on the same page. Okay. All right, you passed. I'm sorry, Mr. Jackson, questions?
Yes, ma'am. Thank you. Ms. McIntyre, I want to go back to you. If you're looking at your report, would you go back through or go back in your report to where you're talking about the visitations with Brittany with her child? Can you look at that with me?
Yes, sir. I do have it pulled up.
Thank you. I think that your testimony was that it was, in your opinion, that her last visit was on September 26th of 2023. Is that correct?
Yes, I do need to correct that. It was October 17th. I have a lot of detail in that court report, and I apologize I didn't read it fast enough.
No, that's fine. I was just wondering, and on that particular date, on October 17th, that was a 2-hour in-person visit, was it not?
That was a 2-hour. We had to make up from the week before because St. Francis did not have a vehicle available to transport her, and she did not have her own transport. So we made up the hour that was our fault.
Okay. And how'd the visit go?
Her visits usually went good. Hadley was still a newborn, super young, but they usually went good when she had them.
Okay. And if I'm not mistaken, I'm not trying to put words in your mouth, but I think that you had testified that you had last contact with Brittany on November the 20th of 2023. Does that sound accurate?
No, sir. November 7th, 2023.
November 7th of 23.
That's correct.
Okay. Well, in your report, I'm looking at your report where you all had submitted on the drug testing where you said that she had failed to appear. And on the 27th of February, you said that she failed to appear as directed. So somebody had contact with her in order to give her notice of that drug test. Wouldn't you agree?
Are you talking about November 27th?
Yes, ma'am.
I sent a text message just like I always had, requesting her to go drug screen with no response to me, as well as no show to the testing facility.
And you did that for December the 14th as well?
That's correct. I attempted contact and had no response from her.
Okay. Just out of curiosity, did you provide her with a notice of this hearing through the text message through to her phone number?
I did not for this hearing. I didn't for this hearing, but I did every other hearing prior to the day.
Yeah. Okay, I'll pass the witness.
All right, Ms. Archer.
Ms. McIntyre, are you confident that you had Logan Cooper's correct phone number after he was released from Potter County Jail?
I am, because I've been in communication with his mother.
I have no further questions.
Ms. Savell?
Ms. McIntyre, you've been the caseworker for the entire time that it was in the conservatorship section, right? And you said that when you told Ms. Chenault that the visits were going to be suspended in October, that she was pretty angry about that.
She was pretty upset with me, yes.
Okay. And so did you explain to her that what she needed to do to get those started back up was simply take a UA and have that be negative?
Yes, I did.
Has your phone number changed at any point during this case?
No, ma'am.
Has she been to the St. Francis office?
Yes, ma'am. Actually, with me, I transported her to the office. We had a meeting and I transported her to the UA. So she has been to my office with me.
And the location of that office has not changed since this case started.
No, ma'am.
You've been out to her home?
That's correct.
And what do you see when you go to the home?
So she's never let me inside of her home, but her front door is always decorated for every season, and her car is sitting right out front, but she's never let me inside of her home.
And you're texting her on the same phone number you've always texted her on?
That's correct.
So at any point, knowing that all she had to do was drug test for you and she could get her visits back, she has never reached out to you since that time?
That's correct.
She's never shown up at the office?
Not to my knowledge.
And you have to try at least 3 different times every month to reach her?
That's correct.
Would you agree that Hadley is thriving in her placement?
Definitely.
And that's been the same placement she's been in this entire case?
Yes, they took her home from the hospital.
I will pass this.
All right, Mr. Trout, anything further?
Nothing further, Your Honor.
Okay, department rest.
Department rest.
All right, Mr. Jackson, any witnesses to call?
Your Honor, I don't have any witnesses to call. I've looked at I don't have any proof that my client has been given notice of this hearing. I'm double checking that in case that email might not have been put into my file. But this time I intend on calling any witnesses.
All right. Okay. Ms. Archer,
I have no witnesses, Judge.
you rest.
I rest.
All right. Ms. McIntyre, what notice do you know that mother was given of today's hearing?
Not of today's hearing. As I said, as I testified, every other hearing, I've sent a text message each time. I did not notify her of this hearing. I have had no contact with her whatsoever.
Have copies of the court orders been provided to her?
In the beginning of the case, the court orders were provided to her.
And would she have received a copy of the permanency reports orders?
That would have been through her attorney because I have not had any contact with her whatsoever.
Okay. All right, Ms. Vala?
I have no witnesses, Your Honor, and my recommendation.
Okay, Ms. Vala, what is your recommendation today?
Your Honor, the child is thriving in placement. I think that the evidence presented clearly shows that it's in her best interest that parental rights be terminated for both parties. As to the issue addressed just a second ago about notice, I believe that Ms. Chenault has been represented by counsel this entire time, and he does a great job. And I have no concerns as to whether he has forwarded on any information that he's needed to his client.
Okay. All right, Mr. Jackson, anything further on that, in that regard?
Judge, I had my assistant pull our last correspondence, and it was just in reference to her. It wasn't between us and her. We don't have any proof that my office had sent her any notice of this final hearing. And so at this point in time, I would ask the court to vacate this hearing and give us an opportunity to reset this hearing to give her an opportunity to be present for another hearing because the stakes are so high.
Was she sent copies of the review hearing orders?
Judge, we didn't send the copies. The notes that I had, she was present throughout these hearings, and when she was present, typically I go over those with my client before the hearing.
Well, I guess my question would you all forwarded her a copy of the review hearing order that was from January 9th?
We don't, no, ma'am, we don't have any. I don't believe that happened. If you'll give me a minute, I'll check.
Okay.
And Judge, I was checking, on the review orders, we don't send, our office doesn't send directly to parents. If they're represented by counsel, we send those orders to Mr. Jackson on that. So.
Sure, they go through the attorneys, I understand. She was personally served.
Yes, ma'am.
Aware of the case. I would have given She was present in September, on September 12th for the initial permanency hearing. Was I announced in court on that day, and of course also would have been in the order that our next hearing was January 9th of 2024. She was not present, so she knew about that hearing. She wasn't present on January 9th, where I would have announced the final setting of March 19th of 2024. So I guess what would be critical, Mr. Jackson, would be what communication was had with her or given to her on or after January 9th of
Judge,
2020.
I'm sorry. I don't see here in my notes. I was there for the review hearing on the 9th, and in big bold letters, I said the final was set for today. And I don't, to my knowledge, we haven't had any contact with her since. Well, from what I'm looking at, I don't think we've had contact with her since September.
And Judge, she appeared at the September 12th.
She did.
Yes, ma'am.
She appeared September 12th. But that's where I would have announced the next review hearing order for January 9th. I didn't announce a final date at that hearing. I announced the final date on January 9th.
Judge, may I step out for a moment and check on Victoria's emails and see if anything went out with regard to this order? We did a search in our system.
Hang on a second. Mr. Trout's in a breakout room with his client, so hang on just a second till they get back in.
For this mess.
Mr. Jackson, what did your search reveal?
Judge, it appears from our search that the permanency hearing order for the January 9th, 2024 hearing was not sent to my client.
Okay, or any other notification or communication about the setting today?
No, ma'am.
Okay. Okay. Well,
Judge, I do know that after and I know Ms. Chenal, you didn't announce the final hearing date in September, but after that hearing, Mr. Jackson, Ms. McIntyre, Ms. Chenal all had a breakout room where Ms. McIntyre offered to transport Ms. Chenal to Mr. Jackson's office for all the upcoming hearings, and she never availed herself of that either.
okay. Well, in an abundance of caution, what I'm going to do is I'm going to just recess, and we are going to reset for March 26th at 1 o'clock. And if Ms. Smith, Chenal, whichever is the correct one, appears, then I will allow Mr. Jackson to reopen, and of course allow everybody to cross-examine. If she doesn't appear, excuse me, if she doesn't appear, then there's probably nothing left to do.
Judge, out of curiosity, what time were you planning that on the 26th?
1 o'clock. That works for everybody.
Okay, I am scheduled for an in-person mediation. I don't know if I'm court appointed on that or not. That's at 1:30. Would anybody mind if we started it just out of caution? Even if she does appear, it won't take more than 30 minutes, I don't think. Start at 12:30.
I think the issue may be we've got a final. Is it that morning?
Well, yeah, but if this one won't take long, we can do it in the morning.
Well, see, I've got an in-person hearing at 9:30 that morning.
I'm fine with. Is the other final set that morning? Let me get my calendar in front of me.
There's right now, Judge, there's 2 adversary hearings and a final set on the morning of the 26th. And Ms. Archer is on the final hearing in that case also.
And I believe the mother relinquished in that case, correct?
Correct.
So
I just got, that's the one I got a lot of proof ups on, alleged dads. I think there's like quite a few alleged dads on that one that I got to prove up on. But other than that.
So Ms. Katie, what are we looking at? Probably we'll have a 9, a 9:30, and then a 10 o'clock setting on the Williams case?
Yes.
Well, Mr. Jackson, you think you'd be done by 11:30?
Yes, ma'am. I believe so. It's an adoption, so I should be done. It starts at 9:30.
Everybody else good for 11:30 on the 26th?
Yes, ma'am.
I am, Your Honor.
Okay.
Yes.
All right. Okay, well, let's just shoot for that. But just like I said, in an abundance of caution, I know mom was personally served. I know she's got a lawyer, but I think it is important that we've made some attempt to notify her of the final hearing. So, okay. Okay. So we may have some issue with the link. So, Mr. Jackson, I'll make sure that I'm understanding. Do you think that you all sent her? She's got a different link.
Yes, ma'am. I sent her an email on the 19th and first class mail on the 20th, letting her know about this hearing that's been scheduled for today via Zoom. And I gave her an ID, a Zoom ID number that apparently was for the March 19th docket, not for today's said. This thing started at 11:30, and I'll submit to the court that I haven't received a phone call, and I'll verify if we've gotten any emails that she's unable to log in, but I can verify that with the court.
Why don't you check to see if you've gotten any if she's reached out and requested assistance because she's, can't get into the proceeding, or if you all have a working phone number. And I don't know, Mr. Trout, if anybody with the department has had contact.
Judge, Ms. McIntyre went by mom's apartment. She left a letter stating to contact Mr. Jackson about the final hearing. Also, she forwarded the Zoom link to Ms. Chenault. And I have screenshots of all of that and photographs of her leaving a note on the door. So Ms. McIntyre did try to reach her a few times, and as I said, emailed or texted the link to her for today's hearing. So she had the correct link from us also.
All right. So Mr. Jackson, if you want to just verify on your end, see if you've had any inquiry from mom. So we'll all just stay here for just a minute until you can just double check that.
Yes, ma'am. It should take just about a minute. I'll be right back.
Yeah, no problem. Okay.
Judge, we've checked. We hadn't had any phone calls or responses, and my assistant said that whenever she sent these notices out, she sent your order setting final hearing attached to these, and it tells the date and time for your hearing. It just didn't provide the Zoom invitation ID, but Mr. Trout said that they'd already handled that on their end and delivered that to my client's home.
All right. So let's go ahead and we'll go on the record. And Mr. Trout, I'm gonna at least let y'all put on your attempts to notify mom and what's been done in that regard. All right. So we are resuming today. We're still doing this by Zoom. We are still live streaming, and Ms. Taylor is making our record. Ms. Chenault is not present. So I'll let Mr. Jackson, for the record, put what he has done and what he's realized, and then we'll let the department call a witness on that.
After our last hearing on March the 19th, we had forwarded Ms. Chenault via email a notice of the March 26th hearing for today, beginning at 11:30, and provided her with a Zoom ID. It turns out that the Zoom ID that we provided her and both notices that we sent out was for a March 19th docket, not a March 26th docket. I just realized that this morning. We also sent her notice via first class mail on March 20th, providing exactly the same information. It's my understanding in both instances, when these were sent out, attached was a signed order setting, giving notice of a final hearing signed by this court that was attached. In that, it just gave the date and time for the hearing. That particular order did not provide the Zoom ID information. And that's what I have for the court.
All right. Thank you, Mr. Jackson. All right. And Mr. Trout, if you'd like to call your witness or regarding efforts made in that regard.
Yes, ma'am. We call Paige McIntyre. Did you attempt, since our last hearing on the 19th, did you attempt to contact Mother Brittany Chenault?
Yes, I did.
And in what ways did you attempt to contact her?
On March 19th at 3:00 p.m., I typed up a letter that had my contact information in it, as well as Joel Jackson's contact information in it, requesting that she give us a call as soon as possible in regards to her final hearing for her DFPS case. I also went and I put that in a St. Francis envelope and placed it on her front door as well. as on March 20th, I texted both her and Logan Cooper the correct link for today's hearing.
Okay. And you texted those to the numbers that, as far as you know, are still the correct working numbers?
That is correct.
And as far as mom's concerned, it was the last number that you were able to contact her on?
That's correct.
Right, if you'll give me just 1 second, I have the exhibit of the letter and the screenshots. I will send to the court and to everybody. Just so we have that also. Did you ever, Ms. McIntyre, at any time, did you ever hear back from mom?
No.
Did you ever hear back from dad?
No.
Nothing by text, email, phone call, and no form or fashion have you heard from them?
No form of communication has been had since
There we go.
October with either client.
Ms. McIntyre, do you see what's on my screen, exhibit number 11?
Yes, sir.
Can you tell me what that is?
That's the letter I typed up and placed on Brittany Chenault / Smith's front door.
Okay, and this is identical, nothing's changed on it, the letter that you attached to her door?
No, sir, that's identical.
Okay, and what day did you say you attached this?
The same day we had court last week.
Okay, so the 19th, last Tuesday?
Yes, sir.
Okay. Your Honor, I'd ask to admit exhibit number 11, which is the letter that was just testified to that was left on mother's door.
Any objection?
No objection.
No objection.
All right, petitioner's exhibit 11 will be admitted.
Thank you, Your Honor. Ms. McIntyre, can you tell me what exhibit number 12 is?
A text message that I sent forwarding the link for today's hearing to Brittany Chenault / Smith.
Okay. And we see here that it says Wednesday at 3:30. Was that last Wednesday, March 20th?
That's correct.
Okay. And this is sent to the phone number that you have for Ms. Chenault,
That's correct.
and you received no reply to this.
That's correct.
Your Honor, I'd ask to admit exhibit number 12, which is the screenshot of the text message that was sent by Ms. McIntyre that was just testified to.
No objection?
No objection.
Your Honor, may I take this witness on board real quick?
Yes, you may.
Thank you. Ms. McIntyre, I'm looking at exhibit number 12 with you. It just says register in advance for this meeting. Would you agree with me? It doesn't provide a Zoom ID number on this?
As we all know, when you click that link, it lets you register, and then the court emails you the link that you clicked to register for, like, to be able to attend the Zoom meeting.
Okay, but for the record though, this particular invitation that you're sending does not have that information on it, correct?
It would if you click the link as it directs you to.
Okay, but that number is not on this exhibit, correct?
That number is emailed to you after you register. The court emails that back to you.
Okay. Where on this exhibit does it provide that number?
It wouldn't until you register as directed, and then the court will email that right back to you.
Yeah. Okay. All right. I'll pass the witness, Your Honor. No objection to the exhibit number 12.
Petitioner's exhibit 12 will be admitted.
Ms. McIntyre, you don't get the link until you register, but it does state the hearing is for March 26th on the 9 o'clock docket. Is that correct?
That's correct.
Ms. McIntyre, can you look at exhibit number 13 that's on the screen? What is that?
The exact same text message I sent to Brittany. I also sent to Logan for today's hearing.
Okay, so you sent us to mother and father.
That's correct.
And you didn't hear anything back from Mr. Cooper either?
No, sir, I did not.
And no other further contact outside of this from him?
That's correct.
Your Honor, I'd ask to admit exhibit number 13, which is the identical text message that was sent also to father that was just testified to.
Any objection?
No objection.
No objection.
No objection.
All right, petitioner's exhibit 13 will be admitted.
I'll pass witness, Your Honor.
Okay, if we're done, okay, I was gonna say you can stop the share screen if.
Yeah, it takes me a second to remember how to do things on this.
That's okay. All right, anything further from the department?
Nothing further from the department, Your Honor.
Okay. All right, anybody else have any questions of Ms. McIntyre?
No questions.
No questions.
No further questions.
Okay. Okay, let's see. I'm trying to remember Ms. Zavala. I don't remember if I don't think I asked for your recommendation. I think we recessed prior to that. So if you want to give your recommendation now, that would be great.
Your Honor, it is my recommendation that parental rights be terminated for both parents for Hadley Smith based on the evidence presented. It is in her best interest. And furthermore, she is thriving in placement. I do recommend that that placement continue until adoption can be finalized.
All right, thank you. At this time, then, I do find by clear and convincing evidence that it is in the best interest of the child, Hadley Smith, to terminate the parental rights between the child and her mother, Brittany Smith, aka Brittany Chenault, based on Texas Family Code, Section 161.001, subsection B1, the E, N, and O grounds, and the best interest of the child under 161.001 B2. I also find by clear and convincing evidence it's in the best interest of the child, Hadley Smith, to terminate the parental rights between the child and her father, Logan Cooper, based on Texas Family Code 161.001, subsection B1, the N and the O grounds, in the best interest of the child under B2. At this time, I'll name the Department of Family and Protective Services as the permanent managing conservator of the child, and I will continue the child's current placement. I'll dismiss all court-appointed attorneys after the de novo and appellate timeframes expire, with the exception of Ms. Zavala, who will remain as the child's attorney and guardian ad litem. Counsel, as always, please do not file a notice of appeal until a final order has been signed and adopted by the referring court, if you're instructed to do so. All right, I appreciate everybody reappearing today and everyone's efforts to give notice to the parents again, and we will adjourn. Thank you so much.
Thank you, Anna.
Okay.
Apologize for the confusion, everybody.
Y'all have a good rest of your day.
Hey, Joe.